May it please the court, my name is Peter Sarda. I am a member of the Wake County, North Carolina Bar and admitted before this court. We are here today on behalf of Alfred Littlepaige, a decorated veteran who, after the facts in question, passed away, so we're representing his estate. At the time he went to the VA hospital, he was a 78-year-old man who was, as his wife described, as agitated and somewhat out of control. Yes, ma'am.
Please, no,
Okay.
please continue.
After he was admitted to the hospital in an agitated state, he was taken to the Durham VA hospital in Durham, North Carolina. He was taken to the 9th floor, which is a psychiatric ward within the hospital. Because of his agitated state, his wife was not allowed to visit him for 3 days. At the end of that time period, she visited him, found him on the floor, even though he had been put under a falls precaution while he was treated at the hospital. We are here because this case was dismissed by the trial court for failure to comply with Rule 9J of the North Carolina Rules of Civil Procedure. And if I could just for a second talk about Rule 9J, because I think it's important to understand how it fits into the puzzle of this case. Rule 9J was passed by the General Assembly in the mid-'80s because of a series of lawsuits that were filed against medical professionals. The General Assembly wanted to stem the claims of questionable nature, and in doing so, it would bring relief to the litigation that was presented to the medical professionals, including hospitals, doctors, and some nurses. They passed Rule 9J, which requires a plaintiff in a civil action to certify to the court that he's had the medical records of the alleged malpractice reviewed by a person who is the same education and qualifications as the medical professional in question. That person has to certify that he's willing to testify that the medical care he reviewed reached the standard of care. In other words, that there was a negligent act within those records. We did not assert a Rule 9J certification. I've never made any secret about that. We don't think it's appropriate. And the reason we don't think it's appropriate is because it was a failure to monitor and observe. We contend that that is the act of negligence. If the court would sort of join with me in a rhetorical question that as to who you would name in a situation like this. What field of expertise would you ask your expert to have? Because what we have is no medical care being administered, simply
that doesn't seem to be what you pled in your complaint, though.
I actually, at paragraph 13, I say, as a result of the failure to observe and monitor, the veteran suffered a hip fracture, bruises, and contusions, the result of his fall.
So what about paragraph 17 and 23?
Your Honor, I'm asserting there that it is the due care of the defendant VA Medical Center. And the due care there is not a medical standard, but rather a simple standard of negligence. And we contend that the North Carolina cases that have dealt with this very issue have been circumspect in segregating the medical negligence claims from simple negligence claims. And the leading case that we asked the court to consider is the Blanton versus Moses Common. And in Blanton versus Moses Common, the court said, just because a person has a medical license does not mean that that person must be sued under Rule 9J, and that there are facts in which that rule does not apply.
Part of the problem, I don't mean to call it a problem,
But as Judge Agee pointed out, in that paragraph, you actually refer to the hospital as the defendant.
Yes, Your Honor, I do.
Well, the hospital's not the defendant. The United States is the defendant here. Now, if this occurred at a private hospital or a public hospital, but not the government, if it weren't a government, it weren't a VA hospital or United States facility, you don't deny, do you, that you could actually bring a professional malpractice case against the hospital, correct?
You could bring it if you had the facts to support it and you had a physician willing to testify under Rule 9 standards.
Well, but on these facts, you don't mean to suggest, do you, that you couldn't find an appropriate expert who could come in and say, under Rule 702, any hospital in the world would not permit this to happen for the following reasons. And this expert would refer to standards of the American Hospital Association, and the Organization of Healthcare Providers. I mean, this, in other words, my point is, and this is actually a friendly question to you, this could have been brought as a medical malpractice case.
That's correct.
Okay. Your argument is, that's not how I brought it.
That's correct.
And just because it happened in a hospital doesn't make it a medical malpractice case.
That's correct.
That's your argument.
That's right.
And frankly, the district judge, at least some of the language in the district court's order, seems to suggest that the district court thought that because it occurred at a hospital, it had to be a medical malpractice case.
That's
And your argument, that's not true.
That is correct.
Let me ask you this, if I may, and then I'll be quiet. If you win here, and this goes back as a quote-unquote simple negligence case, would that have an impact? In other words, would a trial of this case on a theory of simple negligence look any different? Apart from the absence of expert testimony, would an actual trial look any differently? Would the measure of damages be any different if it were a medical malpractice case?
No, Your Honor, no difference.
You'd have to prove that the hospital personnel failed to keep him from falling out of the bed.
That's correct.
That's your claim.
That's correct.
And whatever damages flow from him falling out of the bed
Would be the limit of his the government's liability.
Now, would you want to introduce evidence of that, what do you call it, restraint protocol or?
The falls
False
precautions.
policy. I'm going to ask you, now here I'm going to ask you a not so friendly question. What if the government said, all right, we'll treat it as a negligence case, but you can't introduce evidence of the falls policy?
I think that might be that would be a risk that I would run. That the court would have the right to say, no, we're not going to allow it.
Because that bespeaks sort of medical malpractice.
It does.
And you're willing to try the case on the basis of simple negligence.
Simple negligence, Your Honor, and that would be it.
Okay. I didn't mean to lay a trap for you or anything. Sometimes appellate concessions can come back and bite counsel.
I understand. Secondly, the second portion of our argument is that we contend that the facts as presented here, that specifically, that no one was allowed to visit the patient while he was in the 9th floor agitation wing. All of the facts, all of the control over the patient during that time was by the VA hospital. And that there is no evidence of direct negligence. That those facts, as asserted in our complaint and as taken from reading the complaint by the court, we contend constitute the doctrine of res ipsa loquitur, which is an exception from the Rule 9J requirements. So we contend that there are two bases for finding that the trial court erred in dismissing the case. Number one, Rule 9J does not apply to this case because it is a simple negligence case. And number two, that it is a res ipsa loquitur case as pled. And therefore...
So your proof of that would be that the the plaintiff was in the care of the defendants, medical personnel. He was injured, therefore there was negligence.
Yeah, well, res ipsa loquitur requires that, generally speaking, generally speaking, this act would not have occurred absent the negligent omission of some party. And that some party would be an administrator, a clerk, or a med tech, not for medical care.
Could you give me an example of medical malpractice that didn't involve negligence?
No, Your Honor. I think the essential element of medical malpractice is negligence. If I can stray a little bit from the pleadings, I would like to say that Mr. Littlepaige defended his country, received 3 Bronze Stars when he was in Korea. He was a simple laborer. He had only his hard labor as an ability to earn an income. He defended our nation when the time was right. We ask that the court do the same and find that his case fits under simple negligence standards and reverse the finding of the trial court. Thank you.
Thank you, Mr. Sarda. Ms. Shaw?
May it please the court, good morning. My name is Shalika Shah. I'm here on behalf of the United States. Your Honors, as an instant matter, this is a medical malpractice action. The North Carolina Court of Appeals in 2010 spoke directly to this issue. In Deal v. Fry Regional Medical Center, the North Carolina Court of Appeals held that the decision to evaluate for and implement a false precaution plan involved questions of clinical judgment and intellectual skill such that any challenge would be a claim of medical malpractice.
So now you have a case based on concession in which there will be no evidence introduced, no discovery related to the Falls Protection Plan, or whatever it's called. In that light, what's your argument?
Well, Your Honor, looking at the plaintiff's complaint, they don't allege any duty that doesn't arise from the duty from the false precaution plan. And at that point, if the only duty that they're alleging in their complaint is part of the false precaution plan, that they can't separate that out. Their allegation
I'm sorry,
in paragraph...
are you now saying that, I'm not sure I'm following you. Counsel just conceded that he is willing to try the case without evidence that you undertook a special duty, which is what this Falls Protection Plan. Mm-hmm. It's a special duty, a medical duty. Counsel's now saying, look, this could have just been the guy down the street hired to look after somebody's grandfather. And one of the things you know about a 78-year-old in this condition is that you don't run the risk that was run here. It has nothing to do with medical judgment. You disagree?
Yes, Your Honor, respectfully, I do disagree, because in this case, there's no duty that the hospital owed to the person that walked in to keep them from falling out of bed. It's not an ordinary duty. This isn't a normal premises liability question where Mr. Littlepaige was walking down the hall and slipped on a puddle of water. What we're dealing with here is a patient with severe dementia who was agitated and out of control. The doctors were having to evaluate him on a daily basis to identify the risk of him falling out of bed, determine what steps they needed to take to keep him from falling out of bed. That's where the duty arises from. Beyond that, there was no duty on behalf of the hospital.
So if somebody hires the lady across the street who doesn't have a regular employment to look after grandma who's agitated, who's 78 years old, that person doesn't have a duty to ensure that grandma doesn't fall? either fall out of bed or slip and fall once having gotten out of bed? That's not part of what the lady across the street has agreed to take care that doesn't happen to grandma?
Your Honor, just to clarify your question, so lady across the street is no medical professional, just
Yeah,
a neighbor
exactly.
watching grandmother.
She's an unemployed executive for a Home Depot.
I just think those facts are so different from the ones before us, because he wasn't entrusted to the care of a lady across the street. He was entrusted to the care of medical professionals.
And what the argument here is that I'm not relying on, the plaintiff isn't relying on the fact that he was in a hospital.
Well, Your Honor.
That this could have happened anywhere. It was negligent.
And I don't think, and I think the problem with that argument is that that person, while caring for, it's the medical professional that has this duty to prevent them, to consider their diseases and prevent them from falling out of bed. I don't think
But
if
the
you
lady
have,
across the street would also have that duty to
Your
protect
Honor,
my grandma.
I don't think she would have the same duty under.
To keep her from falling and breaking her hip?
Well, I think, Your Honor, if grandma is conscious, if she was awake, she could have fallen out of bed without any negligence on the part of.
That's exactly the point. That's exactly the point. There may not have been any negligence. There may not have been. You may
Well,
win
yes,
the
Your Honor,
case.
I would agree with that. That there.
And you don't have to face a jury, right?
Yes, Your Honor.
Because a private party would have to face a jury on this. But you're going to have a United States District Judge deciding whether there was any negligence.
Well, Your Honor, in this case, I don't think that their specific claims can be separated out from the fact that the duty they're alleging did come out of the hospital. I understand what you're saying, but I don't think that's what the claim that their complaint brings. While they do talk about, in paragraph 13, the failure to monitor and supervise, specifically what they're referring to is the failure to monitor and supervise the execution of the false precaution plan. So while they can attempt to separate out those two duties, I think their complaint completely pushes the two together, and therefore we say that they are making a medical malpractice claim. In North Carolina law, has spoken to this issue and has decided the false precaution plan because of the clinical judgment and skill that it involved.
As I understand the facts here, Ms. Littlepaige actually found him on the floor.
Yes, Your Honor, that's correct. If I may speak to that, so Ms. Littlepaige.
I mean, she hadn't, according to the allegation, she hadn't seen him for 3 days. Mm-hmm. She shows up. Apparently, some health professional actually admits her to the room or escorts her to the room, and she finds him on the floor.
Yes, Your Honor, and I think that that factual allegation alone does not establish the fact that he fell out of bed. Here we're dealing with a patient who had severe dementia.
How long had he been on the floor?
I'm sorry?
How long had he been on the floor?
Your Honor, I don't believe that's in the record exactly how long
because
he's
there
been
hasn't been any discovery.
No, Your Honor, there has not. This case was decided on a motion to dismiss.
Right, and so eventually, if this case goes back, people are going to find out how long he likely been on the floor.
It's possible, right? Your Honor, but I do think it's the plaintiff's burden as the plaintiff in this matter, as the person bringing the complaint and trying to make a claim under res ipsa loquitur or make a claim.
No, I'm not talking about res ipsa. I'm talking about the medical chart's going to show when was the last time anybody in the VA center went in and checked on Mr. Littlepaige.
Yes, I believe the medical records would show that since he was under this.
You've seen him. Counsel hasn't, or maybe he has, but anyway.
Well, and the false precaution plan dictates things just of that nature. When he needs to be checked on, accompanying him to the bathroom, accompanying him for feeding, putting on certain pairs of shoes, whether or not the side rails need to be up or down, and also constant nurse monitoring, seeing his ups and downs. Again, he's a decorated career war veteran with severe dementia. He was agitated, he was out of control, and they had to reassess, medical professionals had to reassess on a daily basis, if not numerous times during the day, to determine what was necessary to keep him from falling out of bed.
Ms. Shaw, I will ask the same question of Mr. Sarda. How specifically, help me understand how the false precaution in this case differed from the fall risk screen assessment that was at issue in Deal?
Your Honor, I think they're one and the same. I think the falls precaution plan is something that results from the falls risk screen assessment. So once they make that assessment, they look at the patient, assess his specific diseases that he's coming in with, his disabilities, whatever the situation may be, identify his risk of falling, and implement certain measures. That plan, those measures, are what's part of the falls precaution plan. In Mr. Littlepage's case, that involves everything that I was just describing: constant monitoring, being close to a nurse's station, constant reevaluation to determine whether or not he needs more or less supervision for that specific day. This patient specifically had a tendency, he was a veteran, and he thought his dementia was taking him back to a time when he was still in the war.
Is this in the record?
No, Your Honor, that's not in the record. But based on that is how the nurses were evaluating what types of risk. For example, for a patient who's going to consistently get out of bed and lay down on the floor, hypothetically speaking, they would maybe want to lower the side rails as opposed to keeping him up. There are different cases out there about side rails, whether or not they need to be up or down. But if a patient's constantly trying to get out of bed, is mobile, those side rails may present an obstacle that would make him more likely to fall and injure himself. And again, these are all issues that are within the medical judgment of the nurses and the doctors administering this plan. Therefore, that's why we claim that this is a claim of medical malpractice.
Well, does it really matter what we think? I mean, we're sitting here to apply North Carolina law.
Yes,
So,
Your Honor.
the question isn't so much whether we can make the distinction, it's what North Carolina law tells us about the distinction.
Yes, Your
that
Honor,
correct?
Judge Duncan's that's correct. So the United States references the court to the North Carolina Court of Appeals in Deal v. Fry Regional Medical Center, because I think that's the one case in North Carolina where they really looked at something that was almost identical to the false precaution plan that we're dealing with at issue. And they found that that was something that involved identifying the risk, implementing steps, clinical judgment, intellectual skill. It was something that came after the North Carolina Court of Appeals decision in Sturgill, which didn't address the false precaution plan. The court in Deal v. Fry specifically said, we didn't address it before, we're looking at it now, it does involve clinical judgment, it does involve intellectual skill, we're treating this as a medical malpractice action. And I think that's instructive and governs the situation that's before us today. I think the plaintiff then goes on to attempt to couch their claim under an exception to North Carolina Civil Procedures Rule 9J and claim that it's a claim of res ipsa loquitur. Well, I think in this case, Your Honor, they failed to allege the three prongs required for res ipsa loquitur. Under North Carolina law, it's required that in a medical malpractice case, to make a claim for res ipsa, that they show that the direct cause is. They can't allege direct evidence of the cause of the injury, that the injury happened while in exclusive control of the defendant, and that the injury is not of the type that would occur absent negligence. And I think on these second two prongs is really the strength of where their argument completely fails.
Is the Deal case binding authority in North Carolina?
Your Honor, I believe it's a published opinion, but
I think it is unpublished.
It's unpublished opinion, Your Honor.
And so is it binding authority in North Carolina?
Your Honor, I do not believe that it would be binding authority in North Carolina, but it is instructive, and it's the only case in North Carolina that's looked at the issue. So I think it's instructive and helpful in this case. As to the claim of res ipsa, the plaintiff has not shown that the patient's injury occurred while in exclusive control of the defendant, because she has failed to eliminate the possibility that he came into the hospital with this injury. As we've already talked about, this patient was very frail. He's coming in on September 18th, had no increase in pain between September 18th and September 21st. September 21st, he was found laying on the floor. Again, his pain remained constant until September 25th, which is when he was evaluated for intestinal issues, not for any potential pain or hip break. There were no signs of any such injury. At that point, incidental to that x-ray, they found the hip break. The plaintiff hasn't eliminated the possibility that he entered the hospital at hip break, and in fact, that's just as likely as him having sustained that injury while in the care of the hospital.
I actually had a question that was triggered by Deal that I don't think you addressed, and that is how unpublished opinions are treated varies from circuit to circuit. So we have rules that say that they have to be, there is no distinction as to how they are to be treated after a certain point. I guess it was 2007, I don't remember. But in any case, circuits can each decide whether or not they are binding precedent in that circuit. Does North Carolina have a rule about that?
Your Honor, I'm
Not aware?
unfortunately
Okay.
not aware of
Okay,
that.
that's
I
cool.
think the case was decided in 2010, and I don't know if that would change your question at all about that, but I'm not aware of the answer to that
Okay,
question.
thank you. I'm sorry. Just occurred to me.
Your Honor,
Are there any cases, has this come up to your knowledge in a Federal Tort Claims Act case before?
yes, Your Honor. It
What's-
has come up in a Federal Tort Claims Act, not in the state of North Carolina.
No, I mean in North Carolina.
In North Carolina, okay. I think it's Wright v. United States, the Middle District of North Carolina did deal with the Federal Tort Claims Act. And Judge Osteen issued the opinion. This is an opinion that was also cited in the district court judge's opinion. In that case, the court found that, I believe that case specifically was dealing with res ipsa loquitur. So it wasn't dealing specifically with the ordinary negligence versus the
So
medical malpractice.
there are no Federal Tort Claims Act cases
dealing with a false
dealing with
precaution.
9J in North Carolina, other than this res ipsa case that you.
There probably are cases dealing with Rule 9J on whether or not I'm throwing and taking a case out where it fails to allege 9J, but not anything that's specifically relevant to the case to the case at hand. There wasn't a federal district court case in North Carolina that spoke to a false precaution plan and whether or not that would require a 9J certification or not. Does that answer your
Thank
question,
you.
Your Honor?
Yes.
Unless there are any other questions from the court, the government, the United States respectfully asks that this court affirm the judgment of the district court based on existing North Carolina law. Thank you.
Mr. Sarda?
Your Honor, I have nothing further to add.
Okay, I did want to ask the same questions. How would you distinguish the fall precaution in this case from the fall risk screen assessment in Deal?
Because it was a screening, Your Honor. I think that it required actual medical involvement. It wasn't just a direction. Make sure the slats were up, make sure the wheelchair was properly braced, etc. The Deal case has actual medical involvement in terms of what the nurses, what the doctors had to do from minute to minute. That's not the case here.
So I'm not understanding, what's the distinction between the screening plan and the fall precautions plan?
It would appear, it did not appear to me, picking up on Judge Agee's question, it appeared to me that, and I can go back and look, that the precaution involved some of the same analyses and safeguards.
I think there are parallels, but I don't think they're the same thing. I think one is just an instruction to the med tech, to the licensed practical nurses, etc. It is make sure the racks are up, make sure the wheelchairs are locked, make sure he doesn't fall. That is not the same as the Deal case.
And by the way, there was no hearing below, was there?
No, Your Honor,
And you never asked to amend the complaint,
I did not.
nor do you think you need to.
I do not.
Okay, thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you. If there are no further questions, we will come down, greet counsel, and take a short recess.